will be looking at current data protection frameworks in India. Through this day, we'll be looking at both, well, not just both, we'll be looking at current and future possibilities of data protection frameworks. I understand that later there will be a comparative analysis of data protection legislation across the world. But for this morning, for this next 1 hour or 1.5 hours, I'm told, we will be looking at the current framework in India. Our panel this morning has a variety and diverse experience of Indian data protection law. Samuel Mani, to my left, is a partner at Mani Chekapal Mathur, a law firm in Bangalore that specializes in data protection and other issues of technology law. Correct me if I'm wrong. Mr. Mani was before that the head of the legal department at Infosys. He's an alumnus of this institution. Raghunath Anandpur is a lawyer with Tapka Legal. His article on data protection legislation was, I think, the only relevant article right now on the Indian data protection law. It was published in a peer-reviewed journal recently. To his right is Rohan Cherian. Rohan Cherian is a technology lawyer. He used to work with AZP and partners in Bombay. He's currently in Madras and will be joining Mr. Parasran shortly. So please welcome our panel. Before we continue, I think we don't have a lot of time, so in a very brief introduction, I would try to locate this debate on, first of all, why we're even talking about data protection frameworks right now. India has for long not had to deal with or even encounter data protection legislation. Pre-independent India, for instance, has a very interesting tradition of privacy and from which you can surmise data protection principles. The Arthashastras, which is I think about 320 BC, talks about the need for state collection of data to build census, which just goes to point that surveillance and data protection is as old and older than the nation state, as old as political authority. Classical Hindu law has interesting observations on privacy, but not as an enforceable legal concept. It's more a philosophical concept, the idea of ekant, the idea of oneness. But it's only in post-independent India, much after independence, to be precise, that privacy as an enforceable legal concept and data protection as an offshoot of that concept arises. For the longest time, until about the 1990s, we were primarily concerned with the state's collection of personal data. And this has for long, and it's still accepted that the state requires, the modern nation state requires data in order to govern. That's the fundamental premise of the nation state. This situation becomes a bit more complex once data is collected by private parties who do not have the authority of law. The issue then is what law, if any, should circumscribe or regulate the collection of personal data by private parties, and for what use can this data be collected. My panelists will be discussing in detail the various issues, the various laws in this area, but I think I wouldn't be amiss if I just pointed out briefly that the first statutory measure, possibly the first major statutory measure, happened only in 2008 with the introduction of Section 43A into the IT Act, under which in 2011 rules were notified, the Reasonable Security Practices rules. Those rules, a copy of them are in the blue folder that's in front of you. You can see for yourself that the rules are not very well drafted. That's putting it mildly. The Planning Commission a couple of years ago, realizing the need for national consensus on data protection, so as to encourage, so as to organize, so as to encourage organized data protection, in an effort to further the economic interests of this country, constituted a commission headed by Justice A.P. Shah, a committee, I'm sorry, not a commission, headed by Justice A.P. Shah. The Justice Shah report was published in October last year, in 2012. It proposes privacy principles which should form the basis for future data protection, but it stops short of recommending what that strategy regime should look like. Now, why is all this relevant? Why is it even necessary to talk about data protection? without going into, in great detail into into theoretical concepts that underpin privacy, I think at a very basic level we should understand that the misuse of personal data can cause harm, and applying the harm principle is the basis for most nation states right now to legislate, most democratic nation states to legislate. It is the fundamental duty of a democratic nation state to prevent harm to its citizens. Also, privacy has now been, well, not now, but has been held in a series of ad hoc and not entirely consistent judgments of our Supreme Court to be a fundamental right. Unlike most other common law countries, India does not have a jurisprudential record of enforcing privacy rights, or even for that matter, recognizing it as a right. The recognition of it as a right is fairly recent, and it's still nascent. In two judgments, in Kharak Singh and in Govind, the Supreme Court recognized privacy as a fundamental right, drawing from the personal liberty provisions of Article 21. But both those judgments must be confined to the facts, and those facts are where police surveillance became a bit too intrusive. There is no mention of data or the collection of personal data. In the Canara Bank case, the court talked about privacy rights of financial information, and in Mr. X versus Hospital Y, or if that's the correct name, there was a need to protect medical data. So in many ways, the issue we're going to discuss today is nascent. We do not have a jurisprudential tradition to follow. So without further ado, I think I invite Mr. Cherian to make his presentation first, followed by Raghunath and Sami.
So I think as Bhairav has clearly illustrated to us, data protection is a very nascent new development in India. And so therefore, where does it originate from? I think as Bhairav rightly pointed out, the Indian Constitution definitely does guarantee the right to privacy, and courts have read the right to privacy well within the right to life. Apart from that, under Indian law, I think we can also establish that there are tortious liabilities for wrongful disclosures of information that anyone holds in trust for another person. But unfortunately, data protection does not, until very recently, did not have a strong backing of the law. And most data protection interests were secured by contract. And therefore, the IT industry, which grew in the late 90s and the early 2000s, focused a lot on what contracts would work with to address these issues. Now, as Bhairav did mention, the AP Shah report was commissioned, the AP Shah committee was requested by the Planning Commission to look at how this would help the Indian economy, given that our robust IT sector was now slowing down and it needed to address international standards to that extent. Now, the Justice AP Shah committee report came up with a number of recommendations on how data privacy in India could be secured. And I think the first point it did make is that we need a specific privacy bill or a privacy act, which would be able to address all the issues in regard to personal information of every individual in this country. And the act would need to stem from the constitutional basis on which this right is going to be enacted in terms of the act itself. The recommendations of the committee also does talk about limited exceptions in regard to what today is currently within our practice, and some which aren't. And to address the issue of inefficiencies in the government system, there was a clear mention that we need a regulator which could be dedicated to privacy issues and data protection issues. Another issue which the committee did address was the fact with regard to the scope of information and the privacy that it demands. And to aid the industry, I think the committee did go on to say that anonymized data should not hold the same standard that individual data would have. Apart from this, it also does say that any limitations with regard to the right to privacy should only be limited committee report also does discuss that there are various laws in India which control data privacy at different levels and in different forms. And I think one of the major recommendations and takebacks from the committee report is that we need to harmonize these laws. And at the moment, there are several laws which sometimes conflict across the industry and sometimes for players who work in different areas in the country. So yeah, and I think while the committee does look at the issue that we do not have, we cannot expect everything to come out of legislation, and therefore there would be certain self-regulating aspects to it. It does require that certain principles stem from the government itself, and certain national principles be set after discussion with industry bodies, which form the framework under which any data privacy and data protection could take place in this country. Now, some very brief points which would form the basis of these principles would be, number one, that there is the principle of notice. Anyone who is disclosing his information should have notice what information is being collected, how it is being collected, and when his consent is required and how it will be disclosed. Apart from this, the data collector is mandated to only collect information for the purpose that he is stating, and he cannot collect it under all-encompassing provision. Similarly, disclosures are limited. Disclosures have to be only for the purpose which are carried out upon the same very principles under which the data collector is responsible, and he has to be accountable both in terms of statute and to the industry with regard to the data that he holds in trust for the individual. I think the main point that we can see is there has to be an overarching principle of privacy which cannot be subsumed by commercial interest. And that's one of the main points which does come out of this report. So that while the economy and its growth is important, the individual's privacy has to be respected and is sacrosanct to anything which develops on that front. Now, the Information Technology Act 2000 was the first step where India tried regulating data privacy and data protection. And while the act was nascent in its first form, there was a provision with regard to confidentiality obligations, but that was only imposed on the government, to anyone who drew power from the government, and with regard to the information he held for wrongful disclosure. Post the amendments which took place in 2008, which came into effect in 2009, a new section was added, Section 43A. And Section 43A provided for a much more stringent regime with regard to data protection and how the industry and private players would handle such data. Section 43A says that data protection can be secured by contract, and in the absence of a contract, in accordance with principles which are laid down under the Act. And therefore, you have, number one, if two private parties have a contract to deal with the issue of data protection, then they would not have to really deal with the principles under the rules. Now, the Information Technology Reasonable Security Practices and Procedures rules with regard to sensitive personal data and information was passed in 2011. Post the rules coming out, the Department of Information, the Ministry of Information Technology released a press release with regard to certain clarifications in the Act. And I think there is some doubt on whether the press release actually changes the law to that extent, and whether such change in the law could be brought about by press release in the first place. Now, to very briefly give you a background of what these regulations seek to do is, while they lay down the standard, they cover these basic principles, that is the principle of consent, the necessity of information, how the information is secured, and how the information is disclosed. The rules are limited in terms of operation to body corporates, and body corporates have been defined to be anyone who is working in a commercial or professional interest. for that information. It is a little restricted because it does limit the scope from non-government organizations and for that very reason the government itself, which would form one of the primary collectors of individual data. Apart from this, the data which is secured is in regard to individuals. Now, the press release went on to say that it could also be data of body corporates, and this is where it actually could be suspect that it expands the definition of under the rules, and therefore may not meet the standards of legislation in this country. A committee on subordinate legislation of the Parliament of India did look at these rules and has passed some negative comments on the way that the rules have been drafted and in the manner in which they have been brought into force, and the delay which has impacted the industry in terms of how these came out much after the amendments to the Act was enacted. So, apart from the rules, I think we have to look at how contract deals with the issue, and the exclusion of contracts, while may be feasible for the industry, may not always work for the sole reason that sometimes commercial interests cannot prevail over and cannot run in harmony with regard to individual rights. And consequently, there is a necessity for some sort of policy or an overarching principles of data privacy and protection, which need to govern these contracts as well between private parties. And sometimes when private parties are going to self-regulate themselves, there is the issue of conflict of interest. So two parties who are contracting to deal with individual data would obviously first consider their own commercial interest before they consider the individual privacy rights. And consequently, by being excluded by contract, they do not have to worry about the principles laid down under these rules. Now, it isn't that India hasn't had a data protection issue with regard to specific sectors before. The banking sector in India has dealt with this on several layers. I think the Reserve Bank of India, which regulates banking operations and activities of banks in India, has always made it clear that the disclosure of customer information must be with their express consent and must be collected only for the purpose that banking companies require that information. Further, I think in the Canara Bank case, which Byron did quote, and other judgments of the courts, the principle of secrecy with regard to information that a customer gives a bank has been upheld. The banks and also the insurance regulator have put an express ban on cross-selling. So therefore, if you were to cross-sell products that banks hold into different divisions and insurance companies that they may be related to, then an express consent is required to use the information that is already collected. And so this is the regime which currently exists under the RBI and to an extent under the IRDA. The RBI also did come out with certain outsourcing guidelines in 2005, which seeks to provide a more robust framework in regard to outsourcing activities by Indian banks. I think one of the main takeaways from that was that the obligations which were imposed upon a bank by the RBI were required to be mirrored in terms of any commercial activity or outsourcing of that information which took place. Further, any information which was actually given out had to be only to the extent of the outsourced process, and with ready access and correction facilities available to the individuals in question whose data was actually being processed. And the outsourcing guidelines also went on to provide for audit rights, which was more an international standard and has only recently made its way into the Indian norm with regard to the reasonable security practices. Now, I think when we look at these pieces of legislation, these guidelines issued by the RBI, and we look at the data protection rules of the government, there is a slight gap. And while the RBI may be limiting its scope to financial information, which is what it addresses, the data protection rules hasn't really mirrored that to such an extent. While the definition of personal information does include financial data as well. Credit history is also covered under the Credit Information Companies Act, which also brings in stringent penalties in regard to anyone who discloses credit information. And consequently, I think with regard to financial information, while we do have a robust framework, it seems to have a mismatch with regard to the standards which are laid down by the government under the Information Technology Act. So I think one of the points that we should definitely look is how there could be harmony across all these legislations, how we can draw from what the existing legislations provide in terms of protection to customers and individual data. And more importantly, I think it highlights the need that we need a privacy and protection law which has an overarching effect over all commercial activity, particularly those in the outsourcing sector with the increased interest in individual data, particularly even with regard to government activities and social schemes. They need to be addressed in terms of the privacy of that information. The UIT project, I think, is one gray area where we are not very sure how that information is going to be secured and how that information is going to be protected, and whether that would be available to the commercial sector at some point. Yeah, so with that point, I think I leave the next discussion to the next panelists to discuss how we have drawn in from various other countries and how we can learn from that experience further. Thank you.
Thanks, Mark.
Good morning. The aim of my talk is twofold. Firstly, to provide background of the data privacy rules, that's to state the possible reasons for its introduction, and secondly, to discuss three key concepts from the data privacy rules that are definition of sensitive data, scope of protection, applicability of the data privacy rules to Indian organizations, conditions for disclosure and transfer of sensitive data. And at the end of each concept, I'll briefly introduce the equivalent provisions under the UK Data Protection Act, 1998. Introduction of data protection legislation in India has been expected for a really long time. The need for the data protection legislation debate became extensive since 2000 onwards, after India started gaining importance in the outsourcing business, particularly from the European Union countries. There were concerns that if India does not enact data protection legislation in a timely manner, India may lose the outsourcing business within the European countries to the then newly formed Eastern European countries, or the countries that provide adequate levels of protection for personal data. Transfer of personal information from the European Union to a third country under the European Union Data Protection Directive is restricted unless the third country provides adequate levels of data protection through its domestic legislation or international commitments. India is not regarded as an adequate country by the European Commission for protection of personal data. The European Commission has recognized only a handful of countries as providing adequate levels of data protection. These are Andorra, Argentina, Australia, Canada, Switzerland, Faroe Islands, Guernsey, Israel, Isle of Man, and Jersey. The United States of America, though not an adequate country providing protection for personal information through its domestic legislation, the European Commission and the United States Department of Commerce have entered into a self-regulatory safe harbor arrangement whereby the US companies become eligible to receive personal information from the European Union by agreeing to adhere to the European Union data protection principles. It is in this background that India in the past had attempted to introduce data protection legislation without much success. In April 2011, data privacy rules were published as part of Information Technology Act Section 43A, dealing with protection of sensitive personal data and security controls that need to be implemented by Indian organizations that process sensitive data. Soon after the introduction of data privacy rules, there was confusion among the Indian outsource providers regarding the applicability of certain rules to Indian organizations performing solely the processing functions on behalf of foreign body corporates. The Indian government was quick to step in and provide clarifications in August 2011 to address the concerns of the Indian outsource providers, sourcing industry. Data privacy rules refer to two distinct types of information: personal information and sensitive data. Sensitive data is defined as a subset of personal information, but the protection under the data privacy rules extends only to sensitive data. Personal information is defined as any information that relates to a natural person, and sensitive data is defined as personal information that relates to passwords, financial information such as bank account or credit card or debit card or other payment instrument details, physical, psychological and mental health conditions, sexual orientation, medical records and history, biometric information, sensitive data received by body corporate for provision of services, sensitive data received under a lawful contract. Sensitive data is defined to include data obtained by any method including lawful contract. The definition does not include public domain information and information obtained under the Right to Information Act 2005. It also excludes sensitive data available in non-digital form. This is possibly because it's not a standalone legislation and it's incorporated as part of Information Technology Act, and also due to the limitations under Section 43A, which restricts to digital data. Under the UK Data Protection Act 1998, the protection is available to both the personal data and sensitive data. The sensitive data is defined more broadly to include items in addition to what is included in the data privacy rules. The information relating to racial or ethnic origin, political opinions, religious beliefs, sexual life, commission or alleged commission of an offense, any proceedings for any commission or alleged commission, etc. Under the UK Act, the conditions for processing sensitive data is higher than that is applicable for personal data, and it also protects sensitive data that is in non-digital form, that is manual data that are structured and readily accessible. Data privacy rules apply to any Indian body corporate collecting, storing or processing sensitive data of any individual through a computer resource. Body corporate is defined as any company and includes a firm, sole proprietorship or other association of individuals engaged in commercial or professional activities. It excludes governments and statutory bodies. It also excludes foreign body corporates processing sensitive data of Indian residents. For example, websites that originate from a foreign location that collect personal data of Indian residents, cloud service providers operating a data center outside India that stores personal information of Indian residents, and cookies that originate from a foreign location. For the purpose of attaching legal obligations under the data privacy rules, the data privacy rules classify